One of the arguments that the respondents make, Mr. Martinez, is that on your reading of the statute, all that a plaintiff has to do is put the words compensatory damages into a complaint, and then the person can head off to federal court, ignoring the exhaustion procedures, which Congress did think were important in resolving what to do about the denial of a FAPE. So what is your response to that?
I don't think that's going to happen. And the procedures, if by tacking compensatory damages onto the complaint, what you're suggesting is that you could sort of circumvent the IDEA process by going and getting all of the IDEA remedies along with ADA remedies for compensatory damages in court? Absolutely not. If you go to court and you have a claim that asks for relief that is available under the IDEA, and you have not exhausted that request for that relief, the court cannot move forward as to that request for relief.
So the court would be required to split it up and send you back on any other claims?
Right. It could dismiss the portions of the complaint that are not properly exhausted, or it could give the plaintiff a choice to get rid of the whole case, and so that the plaintiff could come back later in the whole case. But either way—
And is there something a little odd, even supposing that's true, about two parallel proceedings going on in that way, one for damages and the other for, the relief that an IDEA officer can give?
I don't think there's anything odd. I think sometimes this sort of situation comes up in the law, and I think there's a very ready response to that, which is that if a court thinks that there's an agency considering a similar factual scenario dealing with similar issues, what the court can just do is issue a stay. We think that would be perfectly appropriate if this court wants to say that in the cases, and we think there will be rare cases where parallel proceedings are pending, in those cases—
Why rare?
I think it'll be rare because most parents are going to do what Miguel did here, which is not bring the parallel proceeding. Rather, in the real world, the way these cases tend to be litigated, parents do not typically have a lot of resources. Their lawyers are busy, they are busy, and usually they're not going to try to be litigating simultaneously similar sets of facts in two different forums. They're going to do one and then the other. As the Chief pointed out, it's possible that you could reach some sort of global settlement that comes out of the IDEA discussion that actually is going to resolve and give you effective relief on your ADA claim as well.